terms of what's happening on India-Mauritius, the tax treaty that is there. They've revised that tax treaty, and that focus is going to be on tax avoidance, the principal purpose test that is there to curb the tax evasion. So we'll be discussing all of that with Punit Shah, partner at Dhruva Advisors, joining in with us. Thank you so much, Mr. Shah, for joining in with us this morning on ET Now. And let's talk about this treaty, right? And this change that we are making. What is the impact that one should actually expect from this? Is it too much worry for investors from Mauritius?
Essentially, what it says is that India-Mauritius Tax Treaty was there for several years now. It provides capital gains tax exemption on the equity shares, on derivatives, on debt instruments. The treaty was amended in 2017, where the capital gains exemption on equity shares was taken away, and capital gains exemption on the derivatives and debt instruments continue. There used to be the provisions like general anti-avoidance rules like GAR, which required the investors like FPIs who are based in Mauritius need to have substance in Mauritius in order to claim the benefit of India-Mauritius Tax Treaty. There is another provision like principal purpose test or MLI, which further requires that the FPIs or any other investors which are based in Mauritius need to have a commercial rationale or a justification to be organized or to be based in Mauritius. Now, this amendment is proposed in the India-Mauritius Tax Treaty, and that could become effective any point of time now once the protocol is notified by both the countries. Now, this PPT or MLI test is actually much stringent and has a much higher threshold of the commercial rationale to be based in Mauritius as compared to the GAR provisions where only substance was required. So the impact would be that all the investors, such as all the private equity investors, FPIs, they will have to now examine as to whether they have enough commercial substance, reason, rational justification to be based in Mauritius when the tax scrutiny happens. And
Sure.
once they're able to convince the tax authorities about their presence in Mauritius, in that case, they should be considered to be validly constituted there, and the tax exemption should continue for them.
I think that's what the big paradigm shift is, Puneet, that you talked about, the PPT, the purpose test that these companies are likely to go through. Rajesh Gandhi, partner from Deloitte India, is also joining us on the show. Rajesh, what's your understanding of why the government is probably looking at this PPT as well? And is this a paradigm shift, or this is first of its kind, perhaps, that we are looking at this PPT kind of, analysis there?
Yeah, thank you. Thank you for inviting me. See, this is a part of the global agreement between OECD member countries and many other countries. Mauritius was so far excluded from this additional requirement, whereas other countries, Singapore is often in the comparison with Mauritius, Singapore was included, and so were many European countries. So Mauritius is now part of the same framework. So in that sense, the requirement is not harsher when you compare that with other countries. But yes, so far as Mauritius was excluded, the requirement was comparatively lighter. And I'll quickly take you through a couple of comparisons. One is that under the Indian law, when PPT was not there, the Indian law GAR applied. There's a clear grandfathering for any investments made prior to 1st April 17. No questions will be asked. The residence certificate will be used for granting treaty benefits. With the PPT coming in force, there is no grandfathering in this particular PPT. So it is possible that even where you made investment prior to 17 and you had a protection under Indian law, now with the PPT, the Indian tax authorities will be well equipped to question you and probably in certain situations deny tax benefits for past transactions.
Right. So a possibility that this could come in even retrospectively, Puneet, is that something that you would say that, this is because the effective date is still not something that we've clarified on. So there is a possibility that this could be retrospective then?
It is retrospective in nature, or rather it is retroactive in nature. The protocol itself says in Article 3.2 that this protocol, as and when it will be notified, it will be applied to every transaction which is entered into post that date, and taxes levied on that transaction, irrespective of the date of investment. So even if the investment was made, say, 1990 or 2000 or 2020, but the exit happens by the FPI or a private equity investor today, then the PPT would be applicable, this protocol would be applicable, and therefore there will be scrutiny of that capital gains exemption if it is claimed by the private equity investor or the FPIs, and the investor to prove the substance and to prove the commercial rationale to be in Mauritius and claiming the capital gains exemption. So yes, to that extent, it is retrospective in nature, and I think there should be some, unlike GAR, which was grandfathered when it was introduced in 2017, this is retrospective in nature, and there could be some representation made to see that this is not retrospective in nature, but it is prospective for all the investments made post the notification of protocol.
So you are saying for now, the reading suggests that it is going to be definitely retrospective in nature. But Rajesh, if I bring you in the discussion, have you heard anything from your clients recently as a worry for this DTA or amendment which has been there? Because I'm trying to understand is if there is going to be a sudden rush for selling as well. For now, we don't know the effective date, but do you think this could result in a sizable reduction into the flows that we were getting in from Mauritius?
Yeah. So I think speaking with our clients, there are a couple of concerns which are being raised. One is that it is retrospective as discussed for investments P17, but also is it retrospective that wherever I earn some gains until the date of the protocol, let's say in 2020 or 2016 or whenever I made some gains, because the Indian statute of limitations extends to 10 years, is it possible that tax authorities will reopen such cases from 2014 and try to deny treaty benefits even in such cases? So that's question number one. And second, the other which we are getting from clients is that those who do not have a lot of substance in Mauritius and not be able to justify based on their investment pattern. Under the PPT, what you need to do, you need to convince the tax authority that you had, let's say, 3 or 4 reasons why you chose Mauritius. Tax was not any of those reasons. You had non-tax commercial reasons for choosing Mauritius. So in certain situations, that may be challenging for certain kinds of entities or funds, and that is what is worrying them as compared to the existing provision.
That's the feedback you got from clients, but what's the feedback from government? Because the official notification has not been made, right? Is there any chance of maneuvering that? Do you think the government is in a mood to perhaps have the conversation with you and make those edits that you guys are recommending, or any feelers?
Not so far. I mean, so this has come quite. I mean, just a couple of days back. I don't have any feelers from the government on what their thinking is, but the way the protocol is drafted and designed, the intention I think looks to be quite clear to have a retrospective application, at least in relation to investments prior to 17. It may not have retrospective application for past transactions where exits have happened in the past. I mean, I think that may be a little bit of a too much of a far stretch to apply the law and create unnecessarily, nervousness in the market. But at least for past investments, I think they will certainly want to apply this law.
Okay, Rajesh, as well as Punit, thank you so much, for joining in with us this afternoon on ET Now, giving us an understanding in terms of the changes that are made in the India-Mauritius Tax Treaty. Pleasure having you both on the show. Yes, that's Rajesh as well as Punit joining in with us. But
if you like this video, then like, share and subscribe to ET Now.